know.
opposed to aspirations.
I know. Not only discussing the law, which is kind of a dry subject in and of itself, but like talking about these esoteric concepts of expectations of privacy. It's really good times. We'll have a good time.
Pretend you're in trial trying to explain it to a bunch of 10th graders. So, looking at your bio, it turns out you clerked before more Supreme Court justices than I've met magistrate judges. So, what's the deal with that? Maybe we can spend the second half hour talking about that.
I try to change it and turn everything.
I'm going to steal Ben's microphone to call the room to order because the AT&T Center has stolen our podium. Well, welcome back for the afternoon sessions where we take a distinct turn towards the legal side of all of this, obviously drawing along the way on all the broader themes and angles we explored this morning. For session number 3, on the Fourth Amendment context of all that we've been talking about, I'm very happy to introduce my UT Law School colleague, Ahmed Ghappour. Ahmed, for several years, has been litigating national security cases at UT through what was previously known as the National Security Clinic and is now known as our Civil Rights Clinic. It's an extraordinary docket that's ranged from Guantanamo cases to cases, criminal prosecutions linked to Anonymous, which is, I think, fascinating and apropos in some ways of the topic we're now going into. He wears many hats. He also serves as director of the National Security Defense Project, which has a broad docket of cases, including a number of cybersecurity-related matters. His scholarship, like his work, reflects the intersection of law, policy, technological change, and security, with an emphasis on cyberspace. And lastly, I'll note that very much unlike me, he has the technological chops to back up his work in this area, having done work as a diagnostics engineer with expertise in complex high-end computer systems. It's all way beyond me, but hopefully won't be beyond you. Ahmed, the floor is yours.
Thank you so much, Bobby. I will attempt to just live up to 13% of that introduction, and I think we'll all be fine. It is with great pleasure that I introduce the speakers today. To my immediate left, Hanni Fakhoury, who is a staff attorney at the Electronic Frontier Foundation, which I will note is the first civil liberties organization that I ever heard about as an engineer in the Silicon Valley. He has written numerous amicus briefs in state and federal courts throughout the country on warrantless police surveillance and cybercrime. He's been published in The Jurist, New York Times, Slate, and Wired magazine, and is sought after as an expert on electronic surveillance issues in criminal law. Before joining the EFF, Hanni was a federal public defender in San Diego, where he tried numerous jury and bench trials and argued and won multiple times before the Ninth Circuit on appeal. To his immediate left is Mr. Benjamin Powell, who is a partner with the law firm of Wilmer Hale, and his practice focuses on cybersecurity, data breach, privacy, national security investigations, and international investment issues. But that's just the start of his bio. I can go on forever, but I will just note a couple of points. First, he was general counsel to the first 3 directors of national intelligence since 2006. He's worked closely with Congress to modernize the Foreign Intelligence Surveillance Act, an effort that resulted in passage of a landmark comprehensive bipartisan bill, the FISA Amendments Act, which I am sure we are going to be discussing at some point on this panel. He has served as Special Assistant to the President and Associate White House Counsel, and he's clerked for both Justices Stevens and White of the Supreme Court, and a number of other clerkships that if I were to list, it would probably run into the next panel. He's also a former engineer, much as myself. So, as the title of today's panel indicates, the Fourth Amendment, and indeed any provision of the Bill of Rights, probably cannot and should not be limited to the specific historical incidents that gave it birth. In the Fourth Amendment's case, that would be the use of general warrants during the colonial era, conveniently at that point called writs of assistance, and issued by King George, and extremely broad in scope, allowing the general search by law enforcement of any physical property, including homes. So as a result, the Fourth Amendment of back then was very much cabined to notions of property, physical trespass, and so on. At its inception, of course, in 1791, it was not intended to protect privacy on telephonic communications, simply for the reason that telephones didn't exist back then. And of course, today, there are new technologies, and they are very much a reality that society must decide how to regulate, and so on. And we will endeavor on this panel, and then that'll be the last you hear from me, but to look at the Fourth Amendment in the context of three developments since 1791, in addition to the telephone. The first would be the modern threat, and that is an amorphous, stateless, asymmetric attacking threat, whether it be terrorism or the rise of the cyber threat, and the corresponding changes in the nature of national security and therefore foreign intelligence requirements. The second factor that we'll be looking at is the phenomenon of globalization, both in terms of communication technology, but also in terms of the presence of the United States in terms of its omnipresence in terms of communications technology, and also the fact that it has to adhere to multiple laws across regions and countries. And third, of course, we're going to be looking at the factor of emerging technologies that both capacitate mass surveillance and at the same time the proliferation of technologies that allow individuals to engage in online activities, whether they be nefarious or benign, but in an undetected and unsurveillable manner. So, Hanni, the Fourth Amendment in technology, that seems to be right up your alley, both as a digital rights attorney but also a former public defender. How is the expectation of privacy guaranteed by the Fourth Amendment affected by technological advancements?
Well, that's a really interesting question to answer, and I think it's one that there's going to be a bit of dispute about. And that's because, as Ahmed kind of alluded to, the Fourth Amendment was written at a time when, there was no such thing as a telephone or the internet or all of these modern devices and modern capabilities that we all use today. And, there was a shift in the 1960s in the Supreme Court jurisprudence on the issue where the focus of Fourth Amendment protection shifted from trespass-based theories, meaning that the police couldn't step onto property to overhear a conversation, for example, or use a spike mic that they physically installed into a house to listen in on a conversation, to something broader than just these property-based notions. And instead, the court came up with this notion of that people have an expectation of privacy in certain areas. And the real kind of, the real issue in the NSA debate, but even beyond the NSA issue is, well, what does that mean in the 21st century? Does that extend to phone calls, emails, text messages, that sort of thing? And the Supreme Court has given us little bits and pieces of guidance on how the expectation of privacy evolves with changes in technology. So in 1967 in Katz, it said, well, a person has an expectation of privacy in a phone call they place in a public phone booth. Later the court said people have expectations of privacy to be free from tracking of their movements in private places, though not necessarily in public places. That was in the 1980s. In 2001, in a case called Kelo, the Supreme Court said you have an expectation of privacy from the government's use of a thermal imaging device to monitor heat levels inside your house. But they've never gone, but since that decision in Kelo, they've really kind of been very silent on, well, what about a text message? Or what about my email? Or what about my Facebook messages? Or what about my phone metadata? And that's why there's this robust debate going on right now about what are the scope of that expectation of privacy in the digital age. I think compounding the issues, in addition to the Supreme Court not really putting a lot of guidance on how the Fourth Amendment applies to new technologies, we've also seen that the failure of the court to explain and update and provide guidance has led to lawmakers and courts and policymakers relying on older cases that involve antiquated technologies, for example, to justify certain forms of surveillance that they're engaging in. So, for example, we talked this morning, there was mention of the 215 collection program, which collects the metadata about phone calls at people's places. And one of the reasons, or one of the ways the government has justified that program as not requiring a search warrant is by saying, well, in 1979, the U.S. Supreme Court, in a case called Smith versus Maryland, said, well, people don't have an expectation of privacy in the phone numbers that they dial, and therefore, in that specific case, the Supreme Court said police could install a pen register, which just captures the phone numbers you dial without a search warrant. Well, then the court didn't really say anything else about that issue for 40 years, and now today, the argument becomes, well, under Smith versus Maryland, you don't have an expectation of privacy in this phone record data, and even more generally, you don't have an expectation of privacy in information you leave with third parties, and therefore, that is the legal justification of the 215 program. And there's some real issues there, and there's some real problems, at least in my opinion, there's some real problems with taking a very narrow, limited case that was limited to its facts and applying it in a larger scale. But that is the challenge when it comes to these new technologies. And it's not just 215, it's an issue with 702 collection, it's an issue with, forget the NSA for a second, just think about domestic law enforcement, solving burglaries and robberies. It's an issue there. And it's something that courts are gonna have to address, legislators are gonna have to address, and the general public needs to have a conversation about.
Just a quick follow-up on that. What is the problem with metadata in your view in terms of the privacy harm?
Well, I think as Bruce was saying more eloquently than I can say at lunch, that metadata really can capture a very revealing portrait of who you associate with and where you go in your history of associations and your habits and your patterns of movements. And it tells a story about us that was not possible to be told in 1979, because in 1979 everybody had a landline, and that landline necessarily put you in a geographical place, your house, or wherever that landline was installed, your office or whatever. But today we all carry, our cell phone, and this thing tells me, broadcast that I'm sitting here in the AT&T Center in Austin. It probably says, because I'm logged into the AT&T Wi-Fi, it says that I'm in classroom 204, I think we're in. And it says that sitting to my right is Ahmed, and to my left is Benjamin, and that there's a whole bunch of very esteemed and important people in this room, and that we're having a conversation about the NSA, and that it's going to reveal that when this panel is done, that I'm going to leave the classroom. I'll probably go use the restroom because I had too much coffee, and then I will go and leave the AT&T Center and go, I have a plane to catch, so I'm going to go get to the plane, and it's going to show the route I took to get to the airport, and that's just one piece of this. And if you take that information and you aggregate that information over an extended period of time, over days and weeks and months, it reveals all sorts of stuff about me that I wouldn't necessarily expect another person to know about me unless they were, like my wife, for example. But the issue is, does the limited use of the pen register in Smith in 1979, did it contemplate this sort of richness of metadata? No. Did the Supreme Court in 1979, when it said you could use a pen register without a search warrant, did they contemplate that this was how technology was going to evolve at the time? No, probably not. And so we're right back at that same dilemma where the law hasn't kept up with the advances in technology.
Thank you, Hanni. I just want to make two remarks. The first is I've actually got Bobby's phone, so you're sitting next to Bobby. The second is, so there's... The Section 215 issue has been contested a number of times since the publication of NSA documents released by Edward Snowden. One of the cases produced this excerpt from Judge Leon out in the District Court of D.C. He writes, rapid and monumental shift towards the rapid and monumental shift towards a cell phone-centric culture means that the metadata from each person's phone reflects a wealth of the detail about her familial, political, professional, religious, and sexual associations. ... That could not have been gleaned from data collection in 1979. Records that once would have revealed a few scattered tiles of information now reveal an entire mosaic, a vibrant and constantly updated picture of a person's life, and so on. He ends with saying, it is likely that these trends have resulted in a greater expectation of privacy and a recognition that society views the expectation as reasonable. So what he's saying in a nutshell is the fact that we have these capabilities means we've got a higher, it changes our expectation of privacy around location data and other sorts of metadata. Now, Ben, is this a critique on the collection of data or the use of data? But also, in your answer, just I would just ask that you think about whether the fact that the 215 program and the others that we're talking about today have a foreign intelligence function and a national security function in terms of their collection, whether that impacts your analysis in any way.
Right. So, of course, under and what these cases are struggling with is, of course, and what that excellent, by the way, summary of 200 years of Fourth Amendment doctrine. I'm glad it's taped. I may go back and look at that, but that was excellent. So, of course, the way the court has dealt with this under the Fourth Amendments in Smith v. Maryland is the third-party doctrine in terms of collection, that once you've given the data to a third party, that the Fourth Amendment does not generally come into play. So it's not just been in Smith v. Maryland, it was a pen register and phones, but there's cases on all types of records, bank records, financial records of all types, and those kinds of things applying Smith v. Maryland and the third-party doctrine. So it's not as if in 1979 Smith was decided and nothing ever happened and there's this one case and that's what we're looking at now. And so that's really been a collection approach to things in terms of saying there's a third-party doctrine and the Fourth Amendment's not going to have a lot to say about that if you've given it transferred it to a third party. Obviously, that's come under a lot of scholarly attack and question over the years, and now that's being brought to the fore with those issues. So in that sense, it's been a collection issue, third-party doctrine, collection falling outside the Fourth Amendment. The Jones case that you mentioned, of course, with the GPS tracker, produced a fractured set of opinions for the Supreme Court. At least a number of the justices, perhaps even 5 of them, willing to take a more nuanced approach to things, to ask what we should look at the actual activity that's being undertaken. What is the expectation of privacy? How is this data being used? How long has the surveillance continued for? Again, no majority in the court for that at the moment, but there have been at least a few cases where you get glimmers where people are looking to see, is there another approach besides the third party doctrine that's going to come into play in the Fourth Amendment area. That said, once you move away from the third party doctrine, you have a question of what would replace that. And does it become the third party doctrine, of course, at least has the, whether you call it a virtue or a vice, some clarity to it. Once you get beyond that and you see this discussion in the Jones case where Justice Scalia, of course, takes a common law trespass approach to things and says, well, you've actually seized that part of the car, you've intruded, essentially like coming into my house by seizing a part of my property, putting the GPS tracker on it. Where does that go if you get away from the third-party doctrine and the property doctrine? You look at the 4 justices led by Justice Alito there discussing, well, maybe this wasn't so problematic if the GPS surveillance happened for 2 days, but we could see if it goes for 6 weeks, that's too long. So you'd open up a whole new, what some people call mosaic approach to the Fourth Amendment, and unclear, what kind of guidance and what that doctrine would look like in terms of the types of guidance for, thousands of local police departments, state law enforcement, and of course federal law enforcement. Now your second question is, it's going to be very interesting if these cases come up in the area of national security, because while the court has never addressed the national security exception to the Fourth Amendment and has expressly reserved on those questions, a number of lower courts have addressed that, and its impact on the reasonableness of the activities, and also whether or not the court will even want to address these issues in the context of national security, given the overlay that is there when historically, when you look back, what the government has done in terms of foreign intelligence purposes, when there's a foreign intelligence purpose, that has affected the analysis and approach to these constitutional issues. So I think it's going to be interesting to see how these cases come up and where the court decides to get involved. I think I know Justice Scalia, of course, just I guess gave a speech where he said, we know nothing about the threats facing the country, and we're not really sure we want to be involved in national security. So I don't know. He's one of 9, and I don't know whether that reflects the rest of the view of the court. That said, even in the non-national security context, you see throughout the Supreme Court cases this pleading for the legislature to be involved and give us a framework. And if we think the framework is reasonable, we're going to defer to that framework to a large extent. What Justice Alito says in the Jones case I thought was very interesting. He says, in circumstances involving dramatic change, the best solution to privacy concerns may be legislative. A legislative body is well situated to gauge changing public attitudes, to draw detailed lines, and to balance privacy and public safety in a comprehensive way. So the types of issues that Bruce eloquently spoke about at lunch, about the internet, where are we going with all of these issues of metadata and different types of data? I don't know how well suited we want to look to 9 justices of the Supreme Court over a number of cases to interpret the Fourth Amendment to somehow give guidance in complicated areas of both national security and a framework for addressing these issues. Just a little bit of history here. Of course, after Katz was decided in terms of applying the Fourth Amendment in the electronic surveillance area, Congress responded with a comprehensive framework under the Wiretap Act, and that brought stability to that area. And while you have some cases on the margins from time to time, from a law enforcement perspective, you now have a statute. You follow the statute. You know what is set out there. If you follow those procedures, then you're able to do your job, and you know that you're going to be on stable ground in terms of approving it. So you don't really see Fourth Amendment attacks on the Wiretap Act and other issues.
You mentioned the mosaic theory, and I think I did also for a second. And just to piggyback on some of the earlier talks today, we learned about, I think it was Dr. Landis that told us that machine learning and machine intelligence as a science, basically, the quality of the output that you get from machine learning technologies is almost directly correlated with the amount of data. Maybe it's not directly correlated, but it certainly is correlated. And applying that to the mosaic theory, and particularly with metadata or even with content, it would imply that you might want to actually just collect everything and then figure out what you want to do with it later. In that case, Hanni, where is the harm, if at all? And is there a Fourth Amendment violation? And if it's addressed outside of that context, and Ben, feel free to chime in, how should lawmakers address this?
So the collection issue is really interesting because, the Fourth Amendment, we always talk, most people talk about the Fourth Amendment, they talk about search. But the Fourth Amendment says it prohibits unreasonable search and seizure. So there are two separate, oftentimes related, but sometimes distinct characteristics there. There's the search aspect of it and there's the seizure aspect. And to be clear, to be sure, the capture of all the communications is clearly I'd argue at least it's a seizure. It's also a search. Now the issue is, and this goes back to what we first started talking about, the technology aspect of it is, well, how can the government do a targeted, narrow, particularized search without collecting the haystack, right? The Fourth Amendment talks about unreasonable search and seizure, and also says searches have to be particularized, which generally means, if you think about it in a physical world, it means the police or the government, law enforcement can search or seize, and they can go to the judge and they can get the warrant, but it has to particularly describe the place to be searched. And what that generally means is, if you know the suspect lives in an apartment complex, you can't go get a search warrant for every apartment. The warrant has to say it's apartment number 5. And similarly, if you have probable cause to search for a shotgun, for example, when you go execute the search warrant in apartment number 5, it would be unreasonable to search paper envelopes on the desk because the shotgun can't be in the paper envelopes, right? And so these are concepts that make sense in the physical world, but how do we apply them to the digital world? If I want to capture communications, email communications from someone who I suspect is a member of Al-Qaeda, well, how do I sift through all of the internet data to capture that information, to then filter out the irrelevant, the millions of spam messages in there, and then the million images of pornography that are in there, and then to sift through all the Groupons and living social deals you don't read, and finally actually get to the stuff I want. And this is where there's real tension. And even before the NSA controversy, there was tension and debate in the courts about how to apply these principles to electronic searches. Because if you think about it, the government's argument, which I admit, even as a privacy advocate, I can understand a little bit where they're coming from when they say, well, look, Judge, we have to search and we have to get everything, and we have to search everything to find what it is we want to get, because the crooks aren't going to label the drug ledger file as drugledger.doc, right? And they're not going to label a folder of child porn as child porn picture folder, although that has happened, but it doesn't happen too often. So we have to sort through all of it. And the court said, well, look, there's some. If we allow you to do that, then we're getting into these general type searches that the Fourth Amendment was supposed to do away with. And just because technology has exploded the amount of information you have to sift through, we have to come up with creative ways to think about how to make your collection and your searching of this data more narrow and more particularized. I think the NSA debate is the embodiment of this issue. And Ben, you mentioned after Katz, Congress stepped up and they passed the Wiretap Act to regulate some of this. In the NSA context, the FAA was passed as a means to kind of cabin the law enforcement's ability to engage in this kind of blanket collection. But as we've seen since the leaks have kind of revealed the contours of this program, we're still kind of stuck in the initial dilemma that the Fourth Amendment is designed to prohibit, where you have the massive capture of everything and then you have the sifting through it later. And that is, in the paper context, courts have been very reluctant to approve of that wholesale seizure unless there's a really, really compelling need. And it's I think, I'm not saying, national security is not a compelling need at all, but I'm saying that there isn't that same level of particularity, that same sort of showing like, we need to collect all of these documents in this file cabinet from this business that we suspect is violating tax laws because we want to find the fraudulent tax forms is one thing, but to say, well, we got to capture every communication that travels over the internet so that we can figure out who's talking to who, that's taking it too far. And so that's where there's real debate, and that's where there's some real tension there between the statutory framework, the constitutional framework, and whether we're allowing the government to do exactly what the Fourth Amendment was intended to prohibit them from doing.
Ben, how does the fact that just a couple things to point out. The first is in the context of law enforcement searches and seizures, it makes sense that you're looking for evidence of a crime, et cetera. But in the national security context, is there an argument for we just need to collect everything because we need to detect patterns? And specifically, given the cyber threat and the sort of incredibly amorphous footprint of a cyber attack, which one could make an argument that you actually do need to capture everything in order to be able to conduct a forensic analysis. Not to say that I agree or disagree with that argument, but does the national security context matter?
I think it does matter. I think the court has acknowledged that it matters. Certainly, you have the challenge in front of the Foreign Intelligence Surveillance Court of Review, which was an adversarial proceeding, and that was a challenge to something called the Protect America Act, which was a predecessor to the FISA Amendments Act. It had, I'll say, less rigorous requirements on the government than the FISA Amendments Act, and was upheld in that challenge where they accepted the national security exception, what's colloquially referred to as the national security exception to the Fourth Amendment. So you do see this, and there's been other cases, of course, along the same lines. But that said, I don't think you can ride that too far. So the idea of collecting everything. I think it matters. I mean, we talked about third-party doctrine, we talked about physical trespass and other issues. So the idea, though, that when you flip over to content, so say collecting content, of course, there's statutory provisions that would stand in the way of collecting everything, and collecting the content of everything as a purposeful matter domestically would raise a host, I think, of constitutional and statutory issues. And I'm not aware of anyone arguing that as far as domestic content collection, that A, there's a quote, need to collect everything, or that B, that there's a legal framework to do that somebody is actually doing that. What this often goes to then, of course, is the question of incidental collection when you're doing something for foreign intelligence reasons, where you're targeting people overseas not protected by the Fourth Amendment, but they're in communications with U.S. persons, and whether or not those what are called minimization procedures, how do you protect that incidental collection? We seemingly every so number of years kind of have this debate over the incidental collection, because the intelligence community will say we do foreign intelligence, we collect against foreigners overseas, we target people who are reasonably believed to be outside of the United States or non-U.S. persons, and then you get the argument, but yes, in doing that, don't you get U.S. persons, and aren't they protected by the Fourth Amendment? And are those minimization procedures and how you treat that incidental collection consistent with the Fourth Amendment? That's the way it's been done and handled by the community for many years. The point that you bring up for the future, I think, is very important in terms of cybersecurity and cyber threats, because that, of course, as has been discussed at this conference, the geographical worldwide problem that cybersecurity presents, the cyber threats, who in the government is protecting the networks here in the United States. A lot of articles you read all the time about critical infrastructure and the threats to the critical infrastructure, and we're really struggling, I think, both on the private sector side and the public sector side, about how do we deal with this threat? Does the government have a role there in terms of protecting those networks? What is that role? And how does that fit under the Fourth Amendment if you were to do things for defensive purposes? And all of the recent debate, I think, really shadows and throws a shadow over the cyber efforts that Congress was trying to, frankly, grapple with some of these information sharing and other issues. And I think that has very much lost momentum for now. And we're now in a place where we're going to wait and see what happens. But the cyber debate is in the shadows here in terms of what does this mean for cybersecurity, and what are the threats real? And of course, there's a lot of debate about how real those threats are to the domestic networks, and does the government have a role there that would be consistent with the Fourth Amendment?
So just to clear up my confusion, is there any limit to, and this is an open question, to what you can and can't collect in terms of metadata? Do we want to collect everything? I'm just to be, does the Fourth Amendment actually cabinet somewhere that's clear? When it goes to the Supreme Court, are they going to announce an automation exception and say, well, the fact that no human beings looked at this metadata doesn't make it in any way, shape, or form a privacy violation, and therefore it's completely lawful? Hanni?
Well, I was going to say, I think, as Ben alluded to, the Supreme Court decided Smith, and then lower courts have, in piecemeal, taken on different aspects of metadata. So, there's cases out there that say, well, okay, subscriber information you give to your ISP is not protected under the Fourth Amendment. There's federal cases that have said, well, okay, the records of which cell phone tower your cell phone connects to is not protected by the Fourth Amendment, although there are state court cases interpreting their state constitution, privacy protections that have gone the opposite way. So, not many courts have looked at it wholesale. Since the Snowden revelations, the courts that have looked at 215 specifically wholesale, and there are two courts that have issued opinions on it, have gone the exact opposite way. So you've got Judge Leon in the District of D.C. said Fourth Amendment problem. I can't remember the name of the judge, but the one is Judge Pauly in the Southern District in New York, and an ACLU suit, went the exact opposite way, said, nope, there's no problem with this collection. It falls under Smith v. Maryland. That case is up in front of the Second Circuit now. And so it's going to come to a head at some point. I would argue that, and you kind of were asking, what is the substitute for the third-party doctrine? And I think, in my mind, the way I think of a substitute is, let's forget this idea that every little piece of information we disclose to another means that not only have we lost our privacy expectations in that piece of information, but in the global set of information that flows from it. And instead, we need to have I would like to see the Fourth Amendment go back to focus on kind of a concept of like intrusiveness, which is always present in the Fourth Amendment jurisprudence. I mean, at its core, the Fourth Amendment looks at what is the government's action and how intrusive is it, and does it violate an expectation of privacy? And I think if we refocus on that, and again, state courts interpreting their state constitutions, which can provide stronger protection than the Fourth Amendment, have signaled a willingness to take a more robust view of what how invasive a particular piece of metadata or surveillance or whether we truly expose something to another person is. And I'd actually say even the U.S. Supreme Court has never really made a hard line, flat rule that says anything that is could potentially be exposed to a third party is not protected. I mean, in Bond, which is a Supreme Court case from 2000, involved police, like immigration officials went on a bus and they felt a passenger's piece of luggage, and the Supreme Court there said that violated Fourth Amendment. They said physically touching the bag was more intrusive than just looking at the bag. And just because the passenger put the bag in the overhead compartment did not necessarily mean he allowed anyone to look through the bag or feel the bag at will. That's not what we expect when I get on an airplane. I may expect the person sitting next to me to move my bag over to fit his bag, but I don't expect someone to come and start squeezing and grabbing my bag. If I did that, I'd be like, what the hell are you doing? So, we have to bring the Fourth Amendment back to that place and to really think about that. And technology provides a great way to do that because, like the quote that Ahmed read from Judge Leon, this data is more revealing now than it's ever been at any other time. And probably 10 years from now, it's going to be even more revealing. And so we have to future-proof our Fourth Amendment jurisprudence. We have to future-proof the statutes that are going to get enacted in result of this conversation and this debate. And I think that's a way to do it, to think about intrusiveness and what that really means when we turn something over to a third party or expose it in a limited sense.
And as the technologies have advanced in terms of what the government can do, what they can analyze, and what they can collect, so have the technologies that are available to society and privacy tools like Tor or the use of encryption and so on. If I use encryption and if I use Tor or some other anonymity tool, do I have a heightened expectation of privacy? Should I?
Well, that's certainly under the subjective tests of CATS. You've made some showing about your privacy. There's a lot of criticism of that analysis over there that we should look to what people do to kind of put it on people to have to do things like Tor or encryption and how much that should factor into the analysis. I don't know that you'd want to be in a place that would say, those of us who are technically sophisticated and use Tor and encryption, which is frankly not that user-friendly. We were talking about this at lunch. To these days, where you'd say, well, if you use this, you're going to get this constitutional protection, but if you don't get this constitutional protection. So I don't know that is the equivalent of saying, okay, in the typical Fourth Amendment context where I do things in public view, I have obviously a reduced expectation of privacy. If I know I'm being taped on the web and those kinds of things, the two-party consent rules in the states are not going to apply because I don't have a reasonable expectation of privacy. I don't know that you'd want to get to a place where you're putting on people, using high-end tools and say, well, you get special privileges because you have this technological capability, and therefore we're going to give you this heightened constitutional protection. That would be an interesting Fourth Amendment doctrine to go down that path, and I think the court would be reluctant to go down that path in terms of the sophistication of the tools you use. The court is much more used to talking about plain view and other things where you really show that you know you're going to be in public and not taking any steps to protect your privacy.
So looking at that from the opposite view, Hanni, the fact that anonymity technologies actually make your appearance, or you might appear to be coming from a foreign country. So your IP address might reflect that of, let's say, Croatia or the Netherlands or so on. And as we know, the Fourth Amendment abroad does not apply to non-U.S. persons and does apply to U.S. citizens, but only with a reasonableness standard. In other words, there's no warrant requirement. It's safe to say it's a lesser Fourth Amendment burden, correct? And so in a way, does using anonymity tools actually give you a lesser expectation of privacy?
Well, I share Ben's concerns about framing any sort of constitutional right on who uses what specific technologies, but I think the flip side of that is, well, I like to think of it this way, like well over 100 years ago in Ex parte Jackson, the U.S. Supreme Court in 1896 said, when you put a letter in the mail, you have an expectation of privacy in the contents of the letter. You don't necessarily have an expectation of privacy in the envelope and in the stamp and the address of where your letter is going to and in the return address, but you don't expect the postman to come and see your mail and decide he wants to open it and read what you've got to say and then close it and then reseal it and mail it. We don't expect that. And so to the extent that there are tools out there that help make that envelope even more tamper-proof, I'm all for it. And I would hope that our government would not take steps to undermine that. And there has been some suggestion that they have. And I'm not a technologist. I don't know the specific contours of that or what, but I mean, that's what's been reported. And the real issue is that like something like Tor, which was actually developed by the U.S. government to help its diplomats communicate back home in the United States securely without having other countries intercept their communications, that we should be encouraging the development of these tools, and the development of these tools will, I think, in turn, create a general sense of, email communication is a private thing. It is just the 21st century equivalent of mailing a letter. And we shouldn't decide that just because Google owns the inbox and AT&T owns the pipe that sends that transits my message, that all of a sudden my Fourth Amendment protections no longer apply. Now, I think with respect to email, there's actually good case law that says email is protected by an expectation of privacy. But I mean, it's like one appellate court decision in the Sixth Circuit, and that's it. But we need to have a stronger recognition of that. So to the extent that those tools can reinforce the idea that electronic communications, and especially the contents of those communications, should remain private, then I think that's a step in the right direction, and it's a step towards future-proofing the Fourth Amendment, if you will.
And in terms of the international nature of communications, Ben, we've got a situation where you might be storing your data in the cloud and not knowing exactly what country it's in. So let's say I store my data in the whatever cloud I'm registered with, and it's in Palo Alto, California, and then with this other cloud that I'm registered with, it winds up in Iceland or something. Are we at a point where, because of this international nature, that we have to revisit how we look at expectation of privacy, at least with respect to the geography?
I don't know that they are. So the protections are going to apply to the U.S. citizens generally wherever they are in the world, and in fact, a little noticed overlooked provision of the FISA Amendments Act actually one of the compromises or deals that was made that got bipartisan support for that was to modify something, an obscure provision called Section 2.5 of Executive Order 12333. Prior to the FISA Amendments Act of 2008, you did not need a court order to carry out electronic surveillance of U.S. persons overseas. And that some of that had been actually litigated before the FISA Amendments Act as a statutory matter. Changed that. Prior to the FISA Amendments Act, you went to the Attorney General to get what was known as a 2.5 order. Now, FISA was amended to say that now you need to get a court order to go overseas. I bring that up because it's an example of a place where the Fourth Amendment doctrine did not change, but Congress considered this issue, brought to their attention. There was, debate over the issues, votes taken, and now there's a statutory framework. It's clear. You know what you have to do if you're in the intelligence community or law and you want to carry out certain operations. I just bring that up because it's an example of a place where the things that we talked about in terms of privacy and new technology, are we going to develop that in some kind of very uneven set of Fourth Amendment cases through the courts? That's going to leave many people in a place of instability. Lots of panels, lots of probably law schools talking about what all these cases mean. How does it apply to metadata? How does it apply to records stored in the cloud and those types of things? Is it really a debate that's more suitable for the legislature and Congress to settle? I think the courts, particularly the Supreme Court, and you see this throughout their opinions, what few there are on the issue, all but beg for, please give us a framework on this. There's lots of different issues here. Otherwise, we're going to be, in many of the Fourth Amendment cases in the law enforcement context are intensely fact-specific. And you could say that about lots of constitutional cases, but the Fourth Amendment is special in that sense. When you read these cases, there's one about dog sniffs, and there's a debate. Did the dog step off the path that went to the front door?
I know that one.
Okay, you know that one very well.
Yeah.
So these are, are we going to really proceed in, this type of complex area through a court and judicial solution in incremental cases, particularly in the shadow of national security interests and what people think are real threats to the country? Bruce outlined in his lunch speech many of these types of issues about how do we engineer the internet? What are the kinds of things that we need to think about? Is the 9 justices of the Supreme Court over cases over a decade or 2 decades really the place where we're going to settle these issues, and do we want to settle these issues? So many of the things I think you brought up, may be more suitable for legislative solutions than court solutions. That's not to say that, it's not as if you go to Congress and it's an easy thing and everyone sits down and is reasonable and we all sit around the table and settle it. It's messy, it's democratic, but at the end, you often end up with a much more stable solution where everyone can look at this. You don't have to guess. And, what does this case mean? Did the dog step off the path that went to the door? Was there a knocker on the door that invited people to come up to the door? And try to use these analogies in the cyber context, which I'm not sure they're going to work.
Yeah, and do you train the dog to recognize that there's a knocker on the door and therefore having the ability to go in, right? Hanni, do you agree? Do you think this is an issue for Congress and not for the courts?
Well, I think that's the way I see it is there's room for both.
Sure.
And the reason, and actually not just that there's room for both, but there's a need for both, because the thing that I fear is that Congress, I have probably little faith in Congress, but the history, I think Wiretap Act accepted, the history of Congress legislating around surveillance and privacy issues, in my opinion, has been kind of spotty. So, for example, we mentioned Smith v. Maryland as the pen register case. Well, a number of years later, in 1986, Congress passes a pen register act, which basically dictates how law enforcement can go and install a pen register, and it imposes a reasonable standard, which is okay, fine. But again, they haven't touched the statute in 25, almost 30 years now, and now it's like. That is the authority that allows the government to collect all sorts of metadata. They can't use it to collect location information because of CALEA. You can get real into the weeds, but I'll spare you all. But they can still capture a very rich, detailed amount of information. We mentioned the FAA, and the FAA was a response to outcries based in reporting in 2006, 2007 about some of the surveillance programs in place by President Bush. But the way we're seeing the FAA implemented, and this is something I've actually had a debate with my colleagues about. The question is whether bulk collection of contents is that what the FAA contemplated or not? And some people said no, that's not what the FAA contemplated. And I'm gonna have to ask you about this because you sound like you played a pretty prominent role in that. Is that what the FAA contemplated? Is it not what
You
the
can
FAA
ask him right now, by the way.
and,
No
and,
inner
you
panel
know,
questions. It's like presidential debates.
And the issue is like, well, if bulk collection is what in fact the FAA contemplated, it's unconstitutional, right? And now it's like, well, okay, and then let's say it is unconstitutional. Then we're gonna have to fix the statute. It's like last week we saw like 3 different proposals to fix 215, and it's like, well, which one of these is gonna get passed? And then the political bartering starts, and so. I agree with you that there's a role for Congress to play and to create statutory framework, and that will make clear rules for everyone, and I think that benefits everyone. But we can't put the courts completely in the sidelines because many of the statutory decisions that are being made are based on court decisions, and B, it's going to be up to the courts to, review the constitutionality of these statutes, and C, as much as the courts don't update their Fourth Amendment jurisprudence, unfortunately, Congress hasn't really updated its statutes either. And so that's my fear with Congress. So.
Could you explain the FAA you keep talking about?
Oh, sure.
For a novice lawyer.
I'm glad you brought that up because I was just going to say, speaking of being sidelined, it's time for you guys to ask questions. So, can you explain what the FAA stands for?
So it's the FISA Amendments Act, and it's basically a statutory framework that is part of FISA that allows the government to engage in targeted collection of communication records as long as one of the target is abroad, but it has been interpreted to allow for the collection of Americans' communications. I think it was Clapper just a couple days ago sent a letter to Senator Wyden about they used 702, which is a portion of the FAA, to capture and review communication records of Americans. And so that's what, and I don't think this is whole scale, they're reading everybody's email, but it is a mechanism by which the government has justified as saying we've complied with the statute to collect very sensitive details.
Let me clarify this. The FISA Amendments Act, what it does is it says you can go and you can target people who are reasonably believed, non-U.S. persons who are reasonably believed to be outside the United States. I'm aware of no acknowledgement. There's other people in the room who can raise their hand and correct me if I'm wrong. I'm not aware of any targeted collection of Americans' communications except in a place where they're not in compliance and there's been a mistake made. But I'm not aware of any targeted collection of Americans. What you do get when you do that, just as has happened for many, many, many decades, is when the NSA or the FBI or anyone else, when they're targeting somebody, of course, a U.S. person may show up communicating with that person. So you get what's called incidentally collected communications. That's somebody. So I don't know whether it was how it was collected. I don't recall. It's been declassified. I've just read the FBI report, but you recall Major Hassan at Fort Hood. This is in the FBI report. I don't know what, this is nothing based on my time in government, but Major Hassan, the Fort Hood shooter, of course, was in contact with Anwar al-Awlaki. So clearly the government was doing something to monitor al-Awlaki and had what are called incidentally collected communications of I think it was Major Hassan, the Fort Hood shooter. And so the government needs procedures. Then you've got U.S. person communication. Can you use that? We now know that, now we've got a major who's in the Army who's in contact with a known terrorist, a very significant terrorist. The question has always been in these debates, well, what do we do with that? Because we didn't have a warrant to get this U.S. person's communication, right? We got it because somehow we were covering al-Awlaki's communications. Well, do we ignore Major Hassan? Do we pass that information to the FBI and look at what Major Hassan has done? Why is this person who's a major in the Army in contact with a known terrorist who's undertaking operational planning to kill Americans? That would seem to be something of interest to the FBI. Do we say, oh my gosh, we got incidentally collected U.S. person information, throw it away, let's pretend it never happened? So you have to deal with that issue, and you need some kind of framework for dealing with those kinds of communications, and that's often where the crux of this debate is when you get this incidentally collected U.S. person information. And I see
One over there, and then one also in the back after. Oh, there you go.
Chris Inglis, just to add to what Ben just said, I am aware of no application of FAA, right, the 702 provision or others to enable bulk collection. Of course, we've had a discussion about how 215, which is a completely separate legal instrument, allows for the bulk collection of metadata, which does not include, by the way, geolocation data, so it's restricted in that regard. Further, there are actually specific prohibitions, not implied, but specific prohibitions to use 702, right, under the Foreign Intelligence Surveillance Amendment Act, to reverse target Americans, such that if you know, on average, that this person of interest to you is always in contact with this foreign person of interest to you, if the first person is a U.S. person anywhere in the world, and your intent is to know more about them, and you're trying to be ever so clever by saying, and I can't actually focus my time and attention on them, I'll just focus on the person I know they're in contact with overseas, that is specifically prohibited. And therefore, you can't get to that place unless you, in fact, develop a probable cause for that person explicitly. Finally, I would observe that to the earlier conversation you had, my sense as a practitioner at NSA is that the courts have, and the whole of government has not been the least bit ambiguous about the expectation of privacy of content of a U.S. person anywhere in the world. That's to include subject lines and emails, that there is an expectation of privacy. And therefore, if you are to target that for a U.S. person, you need a probable cause warrant. Our general counsel is here from NSA. See if I've got that right.
Yeah, that is right. I think the one thing I would add on the issue of bulk collection under Section 702, so this is the question of whether you collect content in bulk. In the effort of trying to be a little more transparent at NSA, I recently testified about some of the details of how we conduct this collection. And so it is very targeted in the sense of being directed at particular identifiers, an email address or a phone number. And so while there may be legitimate policy issues, certainly about incidental collection, I wouldn't want anyone to walk away thinking there's a mass intake of content under this, indiscriminate content under this statutory provision.
Do you mean indiscriminate U.S. person content, or?
Frankly, anybody's. So this provision is implemented by targeting particular phone numbers or emails or other specific identifiers.
Questions?
If it goes to trade shows, this is the version of it that was going to be installed at Grand Central Station.
This will be the last one, by the way. Unless anyone else raises their hand, it's really quickly.
This is the version of it that I can't show you that's going to be at London City Airport.
Fakhoury. So there's a simple argument I hear from time to time that says maybe the NSA is allowed to collect whatever it wants, even on U.S. citizens, because that's not information that's going to be used in a prosecution. And the Fourth Amendment is really just a protection on what evidence can be brought into a prosecution at the end. Would you like to dispel that? And Mr. Day, if you're willing to respond to that, opine on that too, I'd welcome your thoughts.
So I think I would disagree a little bit with your characterization of the Fourth Amendment. The Fourth Amendment is intended to be a check on how the government searches and seizes, period. It is not, it can apply in a civil context, it can apply in a criminal context. It is a restriction on the government's ability to engage in a search and seizure. Now,
So OnSite Pro is our latest application with the financial market. It takes,
I have
of all the Bloomberg,
a competing
assets,
speaker.
being news, live TV, obviously.
So
inside an application.
If I may interrupt the voice of God here.
I think we're being surveilled.
Yeah. So to be clear, the Fourth Amendment, it says the government should not engage in unreasonable search and seizure. Doesn't matter if it's for a criminal investigation or a civil investigation. You can bring a lawsuit saying the government illegally searched stuff for tax purposes, whatever. So it's not necessarily hinged to criminal investigation. Now, it routinely comes up in criminal investigations because that's where most of the time the government is searching and seizing. And in terms of the prohibition of the use of tainted evidence, of illegally searched or illegally seized evidence, that's also not really in the text of the Fourth Amendment itself. It's basically a judicially created remedy for the violation of the Fourth Amendment, and it's a way to deter the government from engaging in illegal searches and seizures. And so I think that the issue of, well, it's going to be used in a criminal, most people don't care. They're not going to be charged with a crime. I think kind of is not really the point. The point is, should the government collect and search and seize data in whether it's bulk, under 215, targeted, whatever it may be. What are the contours for that? And to be clear, we've never, I'm not here to say they can never collect anything ever. Long live liberty, okay? What I'm here to say is there are legal limits to how that collection is supposed to take place, to how those searches are supposed to take place. And as I think, we've all kind of discussed, the law has not kept up with the technological realities, and there are questions, and there are lingering questions, and there are difficult questions about what does 21st century search and seizure law look like? What does it look like in the statutes? What does it look like under the Fourth Amendment as a whole? What are the courts going to deal with it? The courts are reluctant. Congress is slow to act. And in the meantime, we've seen this explosive growth in the technology. We've seen, law enforcement's not really sure what to do in many instances. Practitioners aren't sure what to do. Defendants don't know what's going on. We don't know, what our rights are, what the contours of this. But this is the debate we're going to have.
Just to tack on just a 15-second comment before we close the panel, the reality is that this evidence actually ends up oftentimes in a criminal case. The only difference is that there are hurdles to accessing the evidence because it's classified, top secret. Even if you have a clearance as a defense attorney, you're not permitted to look at the FISA application, for instance. And in my view, that is probably the number one concern I have about the use of foreign intelligence, just information, period, in the context of the domestic criminal case. With that, I'm going to close the panel, and thank you guys very much. Thank you very much.
This one? Here we go.
According to the schedule, we would normally roll right into the next session, but what I think we should do is we're going to break until 3:05. We'll have the final two sessions back to back. So go ahead and get breaking now, and then we'll be reassembled for the final session. Exactly.
What did you say, Bobby? I missed that.
But we're just going to break for 10 minutes, and then we're going to have the final two sessions.
I wanted to ask a question, but I didn't want to distract the conversation from the main play, which is a focus on the government or NSA, but I really had this as a legitimate question. So we're very comfortable with corporations like Google, Yahoo, and the like, essentially reading the content at their discretion. But societally, it seems like my kid died, and no one raised that flag, that specter, that's somehow inappropriate. And I get it, right, that there needs to be very specific prohibitions about the government doing that. What's the distinction between the two?
I'd say, actually,
I don't think there is any.
Yeah, so I'm not looking for a pass
what's
on
the
the
big
government
deal
side.
with the government?
No, I actually get that question a lot, and what I tell people is I do think there is a difference in who we expose certain bits of information to. So so to the extent that the government's owns it, right?
Things that private sector
Absolutely. So there's a power in
privacy.
yeah.
This is what you might do to me. It's like, hey, this is private.
Sure. Well, and what I will say is that with respect to private companies, the issue we've always said is, look, if you're going to collect data, you have to be very transparent. And so we said a couple things. One, you have to be very transparent and clear to your customers that you're doing it. B, ideally, they create a mechanism by which the consumer can opt out of that collection. And C, the market has to create alternative services that allow users, that creates a real marketplace so that if you want to use free, massively, massive inbox type email, that you're not just getting using
Using the what's called the
right. Right.
How do I then kind of have my frame of reference? I think that the right standard is not the government. And we need to show cause as to how that achieves that particular expectation of privacy. The next play at the private sector.
Sure. Yeah. Or really burying the consent in like a terms of service where you just click agree and nobody reads it, but then that's all of a sudden legally binding consent.
To essentially get more about that, you'll probably know by
We have a lot of, there's there's a lot of stuff on the EFF website about terms of use and whether they, kind of like how that should be, dealt with.
Can I just disagree with you?
That's fine.